Thank you so much. Yeah, we are happy and glad and appreciative for CARICOM to have invited us to participate in this webinar and to present our COMESA's experience in enforcing rights in digital environment. So, as part of what we are going to look at from the COMESA Competition Commission perspective, we'll be sharing on the mandate of the COMESA Competition Commission and the provisions that are in our law. We'll look at the consumer protection in the digital era. We'll look at the benefits. We'll look at the rights, and then look at the cases that we have handled, and then also look at the emerging issues. So the COMESA Competition Commission is established under Article 6 of the COMESA Competition Regulations, and that is pursuant to Article 55 of the treaty establishing the Common Market for Eastern and Southern Africa, which we call COMESA. The Commission is mandated to enforce, promote, and encourage competition by preventing restrictive business practices and other conducts that deter efficient operation of markets, as well as protect consumers. Our member states are 21, and the list has been provided for those who would want to see the member states of COMESA. So the COMESA competition regulations under Part 5, they prohibit a number of conducts which are considered to be violating consumer rights. One of them is false and misleading representation.
Excuse me, Mr. Kamukama?
Yes.
Mr. Kamukama, yes, I just wanted to let you know that your slides aren't moving. So we're still on your title slide. Yes. Thank you.
Oh. Okay.
Great, thank you.
Okay, thanks. So under Article 5, under Part 5 of the COMESA competition regulations, the law prohibits a number of conducts which are considered to be violating consumer rights, and these include false and misleading representation and unconscionable conduct, both for consumers and for business persons, product safety, again on both the product safety for goods and then product information. In this case, we also have a situation where we can recall goods, especially for defective goods. We recall them from the market. And when a supplier supplies the goods into the market, the manufacturer is the primary responsible person, liable person, but in the event that we are not able to trace the manufacturer, then whoever supplied the product would be liable. Now, the regulations apply to both online and offline conducts. At the moment, we are currently reviewing the law because of the emerging issues, some of which are in the digital area, and we see that there are some gaps, so we are now amending the law. Now, the law applies to the effect it applies that effect which affects two or more member states. So when we are going to use the regional law, we have to look at the effect which affects two or more member states. The member states have their own national laws, but There are conducts which have cross-border effects, and when a matter includes or relates to an issue which has a cross-border effect, the regional law applies. And for now, this regional law applies to all the 21 member states who use this one overall law, which handles competition matters and consumer protection matters. For as long as there is a cross-border effect, then this national regional law will apply. So we go to e-commerce. I think this, I will not spend a lot of time because it's been discussed so much since we started. But what has so far been said, we know that e-commerce helps us, especially online platforms, to quickly get the goods online. We can get as much variety online. We are able to compare products and prices so easily, which sometimes is very difficult for online products, for offline products. We have several modes of payments, which also allow us to even sit at home and be able to pay. And then for the people, the side of the suppliers, it is easier for them to even store as many products because for them they are just putting on the platform. They don't need space like the one required by the offline suppliers. Now, because of these advantages, we notice that these digital platforms are growing, and right now we have about 12 to 24 million sites that are actually providing e-commerce services. And of those, we have about 57% worldwide consumers who purchase goods overseas. And also some of that, we have 55.5 from Africa and about 54.6 from Latin America. So you can see that the business online is increasing. And also we have the sales as they have been growing. We can see that since 2021, it has moved from $5.2 trillion currently to around 6.3 and estimated to going to around $8.1 trillion. So this now is a growing business. But then while it's a growing business, it also has consumer concerns. As consumers, there are a number of violations that are happening online, which affect consumers. And some of them, again, goes quicker on this because they have been covered in one or another. But you find that it's very difficult to verify goods online. We buy something online, it comes when it is either unsafe, defective, or it's a counterfeit. The online platforms don't have clear redress mechanisms. Sometimes the interface that there's no personal interface. You are only going to use only the email or an online form, but you will not be able to speak to anybody. And that also causes a problem for the consumer. The consumer data security has been discussed, but also we have serious areas relating to liability disclaimers and unfavorable terms, and then again unfavorable return policies, whereby the consumer, in the event that they need to, they are aggrieved and they want to take action, it becomes very difficult to take the action because of these unfavorable terms. One other challenge that the consumers have is that, again, within the terms and conditions, it would be specified that the law, the applicable law, is the law in the overseas or in another jurisdiction. And then in that case, it becomes very difficult for a consumer to take action because the applicable law governing the contract is already in the overseas, in another jurisdiction. Even then, when they want to return the goods, then they also have a challenge because there's no local presence of the supplier. Aspects relating to child protection, these are serious areas, and of recent we hear even where the children are being bullied and they are being harassed, and we are even beginning to hear areas where, in some countries, where people are beginning to commit suicide because of the harassment that takes place online. So we also have digital payment challenges, and that now also becomes a problem. You pay to the supplier and the money does not reach. The supplier will not give you the money, but at the same time, also not get back the money which you paid. So these are challenges that are affecting consumers. There are many more, but I just summarized some of these. Now, all these challenges we are looking at are affecting consumer rights. They are affecting consumer rights to health, the right to safety, the rights to accurate information, the right to choose, the right to fair treatment, the right to redress, the right to have your personal data protected. These are fundamental human rights and consumer rights, and they are violated online by platform operators, by the suppliers who supply through the platforms, and sometimes the consumers find themselves with a challenge to have their concerns addressed. Now, if you look at this, you will see we have the suppliers supply through the platform, and the platform supplies to the consumer. But here you can see that on the platform is the one marketing the product. It is the one which receives the orders. It is the one which receives the payments. It receipts the payment and delivers the product to the consumer. But along the way, the consumer would have made a payment which may have gone either through the bank to the platform, or which may have gone through a telecom company which provides digital payment services. But when the transaction goes wrong, who then is liable in this whole process? When the platform is not able to deliver the product, is it the supplier that is liable? Is it the bank which had received the money? Is it the telecom company? When the supplier is claiming that he has not received the money, and therefore he cannot deliver, what do you do when actually the platform that was provided for purposes of payment was provided by the platform, but then that platform channels the money through the bank? So on the account of the platform owner, the money is not there. So the platform is saying, no, we did not receive the money. But at the same time, for you, the money has been spent and you expect to receive the goods, but you cannot receive the goods because the platform claims they did not receive the money. The same thing goes to the supplier. When the goods which come from the supplier come when either they are unsafe, they are not necessarily what you ordered, they fall short of what you ordered, whom do you blame? Is it the platform? Is it the supplier? And then we have all these challenges that come through online platforms. So what have we done? We've been able to handle at least 2 cases. One of them involved an online platform which operates within the COMESA region. It actually operates in Kenya, Uganda, Egypt, and Tunisia. And this platform sells goods, but at the same time, delivers goods which are sold by the third parties, other suppliers. So it sells its own goods and also sells goods which are delivered by other suppliers. Now, on its platform, it was indicating that first it did not show its own legal name. And it was very difficult for consumers to be able to take action in case they were aggrieved, because the platform was not indicating its own legal name. The other issue that it had on its platform, it did not have a clear dispute resolution mechanism. It only had a form where you send in a complaint, but whether they handle or they respond back to you, that was left to them. If they ignore you, there's nothing else you could do, because only the platform had a form, and it is only that form that you could fill in order to complain, and nothing else. And the platform indicated in its terms and conditions that it does not guarantee completeness or accuracy of the information provided on its platform. So even the products which are on the platform, the information accompanying those products, according to what they were saying, is that they cannot guarantee the accuracy of that information. Now, then how would the consumer rely? How would the consumer make a decision, an informed decision, relying on this information, which the platform itself is saying it's not, may not be accurate? And the other thing that the company did was to disclaim that they are not liable for any condition of the goods that will be purchased through that platform. And now, again, it was very difficult for consumers to know, in the event that they have a problem with the good, whom do they take to court? So now we found these provisions on the platform of Jumia. The company is called Jumia. We found them unfair. We found them unconscionable, and we intervened. The company accepted to address the concerns, and it amended its terms and conditions. We also had another case where we had a company which is also operating online within the common market. And for that company, it said that it does not allow consumers to return goods purchased through their website if they are marked shipped from overseas. So the supplier is this company, which is called Karimali. It operates an online platform. The consumer goes online on the online platform, buys the goods. They are delivered, marked, shipped from overseas. But as soon as there is a problem with the product, the consumer cannot take back this product, because the terms and conditions indicate that a good marked shipped from overseas cannot be returned. And then that means that the consumer, of course, will make a loss and will not be able to get any redress. So again, we intervened, and the company, Karimali, accepted to address this problem. So what are the emerging issues? We have a number of them. Some of them have been mentioned, especially like dark patterns, which are now coming up, whereby websites, social media platform, and any other online applications, they use tricks to trick consumers into taking services they do not intend through misleading tactics. Some of these tactics include obstruction. You find that you want to cancel either a pop-up or a web browser. You want to cancel, you cannot cancel. You have to keep reading what is in front of you, even when you want to cancel. You may want to cancel the transaction, but you cannot cancel the transaction. You are shopping, and then as you put your goods which you have selected into the shopping cart, some other goods end up there in the shopping cart, even when you have not included them there, which we call sneaking. Um, you have an interface which is hiding some information, and some of it is pre-selected for you. Because it's pre-selected, you are ending up having to choose what you did not want to choose because of pre-selection, and that is interference. We have forced actions which go on. We have where you subscribe to software, to some service, but when you want to stop the subscription, you find you have no option. The application is not giving you a chance to be able to unsubscribe. So it's like you are forced to continue subscribing. We have aspects which limit price comparison. On the website, on the internet, there are so many softwares and applications which allow price comparisons, which would help you to see which product is cheap and buy that one. But because of price comparison limitations, you are not allowed, and then you miss buying a cheap product. So areas where we have some hidden costs, disguised adverts, bait and switch elements, where they will invite you to come in advertising a cheap product, but when you come in, when you are starting to buy, then they present you with a very highly priced product. And then there's forced continuity, which relates to continued subscribing. You get a software. It says it's for free trial arrangement, and then for you now subscribe on the basis of free trial arrangement. But before you know it, you discover that when the period ends, they continue charging you, even when you had only subscribed only for free trial arrangement. So these are some of the challenges happening relating to dark patterns. Others are scams, which have been mentioned so much in the earlier sessions. And these are serious concerns that are affecting consumers. Now, what then happens with such concerns? Because what we are not seeing is that some of these concerns are very, very, very hard to recognize. We cannot use the traditional measures we have used to detect conducts in the market which violate consumers. These ones require additional resources. They require more experts. They also require technology that can be able to identify such conducts and also be able to address them. The traditional consumer protection authorities did not necessarily use like psychologists. Now, IT experts, sociologists. For now, it is now becoming so important that such authorities start now employing these experts to be able to identify and address such concerns. What are we doing within the Commission, the Commercial Competition Commission? We are trying to enhance collaboration with our member states as far as sharing information is concerned, also in terms of benchmarking. So we collaborate with member states, we collaborate with other competition authorities in other jurisdictions, such as the US, CARICOM, UK, Australia, European Union, to see that we share information and benchmark on how they are doing their work. And we are able to also now incorporate some of those strategies they have in our own plans. We try to build the capacity of the member states through trainings and awareness programs. We do advocacy and education programs to consumers, and we are now looking at how we can apply technological innovations to be able to keep up with the changing technologies and changing consumer violations driven by technologies. Thank you so much. I think I can now stop here.